There have been numerous complaints in recent years from both landlords and neighbours that tenants are smoking cannabis in their rental properties. When neighbours express complaints, landlords are often caught in the middle. So where is the middle ground to resolve this situation? Well, let's get more insight from Rowan Terry, legal counsel at TPN Credit Bureau, who joins us now. Rowan, great to speak to you. Very quickly, can you give us some context on the issue of tenants smoking cannabis in rental properties in South Africa?
Firstly, good afternoon, Hugo, and good afternoon to all of your viewers. The first matter that we have to address is that in September of 2018, our Constitutional Court decriminalised the possession, use, and cultivation of cannabis for private use in South Africa. So that basically means that any person in South Africa is entitled to smoke cannabis within their own property, and this protection is also extended to a rental property. Now, the question of legality comes in when you have to determine if the unit in question has been specified as a smoking unit or a non-smoking unit.
Now, so what are some of the challenges that landlords face when it comes to addressing this issue? Because obviously they seem to get caught in the middle here.
Absolutely. It's very difficult. A lot of the queries that we receive at TPN Credit Bureau is a lot of neighbours who are calling landlords to say, look, the tenant that's in the property, they can smell the cannabis, it's a problem, please can you cancel the lease agreement and tell them to go. But unfortunately, if there isn't a clause within that lease agreement between the landlord and the tenant that states that smoking cannabis in the property is illegal and that there is no smoking at all in that property, only then will it be unlawful. However, if it's not and it's stipulated as a smoking unit, then one person would be entitled to smoke cannabis within that property.
Now, obviously, there are all these neighbours that are making complaints about their neighbours smoking cannabis. What is the nature of the complaint? Is it because they dislike the odour? Is it a case of all of a sudden I'm getting high because my neighbour's smoking? What are the real issues?
So I haven't received any query of a second degree high or second high, whatever that would be. But most of the time, the queries that we're receiving is that it's just a nuisance with regards to the odor and the smell. And this query has come up, even though it has been decriminalized since September 2018, this query has come up quite recently, quite a lot. But obviously, as a landlord, you need to make sure that your lease agreement is comprehensive enough to include that it would be illegal to smoke cannabis in the property if your tenant, if you don't want a tenant in your property smoking cannabis.
So a landlord can make that provision and say you are not permitted to smoke cannabis.
Absolutely. Within their own property, if it's a non-smoking unit, this happens a lot when landlords do not want any damage due to heavy smokers in their own property, causing damage to discoloring of walls, or the smell seeping into curtains or furniture within the property. So landlords are entitled to select if their unit is a smoking or non-smoking unit. And just a suggestion which I always tell everyone is that before you even sign a lease agreement with your tenant, make sure you've had the conversation with them to say, look, this is what I don't want to happen in my property. If that's something you can live up to, great, fantastic, this is the lease agreement. If that's not, then we need to speak now and you can be able to find a property that's more suited for what you are looking for. And to have the conversation, then once it has been done, confirm everything in writing and conclude in your lease agreement so that you would be able to hold that tenant liable for any misconduct in terms of the lease.
Now, what is the rebuttal that you're getting from those that are smoking cannabis in these rented properties?
The rebuttal would be exactly what it's being decriminalized. It's allowed to happen. So that's absolutely what that's the tenant's right in terms of their rental property is to smoke their cannabis if it is obviously stipulated in the lease that it is a smoking unit. The only issue is when there is a certain cancellation clause within the lease agreement, then tenants disputing that, they wouldn't really have a ground because they are in breach of that specific agreement.
Now, I'd imagine that there are some potential consequences for landlords if they do not address this issue in a timely manner. I mean, it could just be relationship-based, but are there any consequences?
Well, absolutely. So in the sense of for body corporates, where tenants are smoking within common areas and they haven't had the correct lease agreements in place and they haven't attached those body corporate rules by not attaching those rules, the tenant would not be liable for it. So any fines in terms of smoking in body corporate areas, the landlord would take on that fine completely and would not be able to pass it on to his tenant, even though the tenant was the person doing the conduct, because it's not in terms of the lease agreement. That's why it's so important to make sure that you have your agreement, it's legally compliant and comprehensive enough to cover every avenue.
Well, you raise an interesting point there, Rowan, and that is the issue of body corporates. So can a body corporate then decide that they're going to illegalize the personal use of cannabis in a particular property and override the contract, if you will, between the lessor and the leasee?
A body corporate would not be able to do that. What a body corporate would be able to do was institute common area rules about whether it's smoking in common areas that would not be allowed. And that would be completely binding on the tenants if, as I said earlier, the body corporate rules have been attached to that specific lease agreement. So it's very important that if there are any body corporate rules pertaining to this, it needs to be attached. So your tenant is also bound in respect of that. But a body corporate would not be able to institute any laws within an owner's own section or property. They would not be able to have their own rules to say no cannabis at all. What happens in the property would be governed by the lease agreement between the owner and the tenant.
Rowan Terry, Legal Counsel at TPN Credit Bureau. Appreciate your time this afternoon.